Hi everyone, a very warm welcome to Thorough Newspaper Analysis. This is the video for the 25th of May 2024. Now let's quickly proceed and have a look at the pointers of discussion for today. Now today we just have the editorial segment, and here we talk about an Indian Express article. So the title of this article is Religion as Sole Factor, Why Calcutta High Court Quashed OBC Reservation for Muslims. Now let's quickly proceed and have a look at this particular article. Now, before we proceed further, let me make a mention of this fact right here. This is an opinionated sort of a piece. That is to say, this is an opinion article by somebody. So we'll try to stick to the factual aspect of it and try to understand the law governing this topic so that it serves our purpose for the exams. So in this light, let's understand the context of it first. See, what has happened essentially is this. Calcutta High Court on 22nd of May has given a certain verdict. What is it and what is the subject matter of that? See, the High Court has struck down a series of orders which were passed by the West Bengal government 10 years back between March of 2010 and May of 2012. Now, what were these orders? See, by virtue of these orders, 77 communities, that is to say 77 classes, they were given reservation under the other backward classes category. Out of these 77, 75 were Muslims. The division bench of the High Court noted that here religion had been the sole basis for the West Bengal Backward Classes Commission and also for the state government to provide reservation, which is prohibited by the constitution and by the court orders. So essentially, please understand, this is what the court has said. See, in every state, there is a commission which was mandated by the Mandal Commission verdict. We'll see that later as well, wherein it stated that you constitute a commission, the work of which primarily would be to collect relevant material and then to make recommendation to the government as to, A, B, C, these are the classes which are fit to be considered other backward classes, and so classes should be taken out of the OBC list of the state. So the primary objective and target or work of this commission is to what? It is to suggest, to recommend to the government that, so-and-so class, so-and-so community should be put in the OBC category so that, reservations can be given to them, let's say in jobs, education, or other matters or other benefits can be accrued to them for their upliftment. So here the High Court has found that the commission for the state as well as the state government did not take into consideration any other factor for putting these 77 communities under the category of OBCs apart from the fact of their religion, these 75 communities. So the sole consideration here was Muslims. The Muslims, they were automatically put under the other backward classes category without perusing, without considering any other circumstance, whether they were socially backward, whether they were economically backward, or was there any other backwardness. Now, in light of this, let's understand the facts of this case. So in its judgment, which was delivered very recently on 22nd of May, the High Court noted that between 5th of March and 24th of September 2010, the West Bengal government issued several similarly worded notifications. Now, what were these notifications? They included 42 classes under the category of OBC, and out of these, 41 were Muslims, thereby entitling them to reservation and representation in government employment by virtue of Article 16, Clause 4 of the Constitution. See, Article 16 and 15, they are specific manifestation of the equality provision which is pronounced in Article 14. So Article 14, 15, 16 primarily deal with the concept of equality. Now, Article 15 and Article 16, they are specific manifestation of the generic principle, correct? Now, Article 15 deals with the fact that, no one should be discriminated against based on these 5 grounds only: religion, race, caste, sex, place of birth. While Article 16 is further specific. It talks about the fact that no one should be, discriminated against in matters of public employment. However, Clause 4 of it, it permits certain reservations in favor of any backward classes of citizens which are not adequately represented in the service of the states. So state is given this leeway that you can come about reservation for the purpose of promoting the interest of those backward classes which are not adequately represented in the service of the state. So on 24th of September that year, which is 2010, an order was issued subcategorizing 108 identified OBCs. So under the state list, there were 108 identified OBCs. These 108 classes, they were further bifurcated into more backward and backward. So 56 were put into more backward category, also called the OBC A list, and OBC B backward were 52 classes. The first challenge in the High Court was filed in 2011 on the ground that the declaration of these 42 classes as OBC, it was based purely on a religion factor, and that the categorization, it is not based on any acceptable data, and that the survey which was conducted by the commission was unscientific, and it was a prefabricated hat that was woven to fit the head. So essentially, the challenge against these orders were on the ground that you're just considering religion as the sole factor. You're not, objectively identifying the data. You're not perusing the data to identify that so and so class should actually be considered the OBCs. In May 2012, Mamata Banerjee government classified another 35 classes as OBCs, and 34 of these were Muslim communities. So this too was challenged in the High Court. In March of 2013, the West Bengal backward classes, other than scheduled castes and scheduled tribes, reservation of vacancies in Post Act of 2012, it was notified. All 77 new OBCs, they were included in the first schedule of this act. 2 petitions, therefore, were filed challenging this act as well. Now, let's understand whether religion can be the sole criteria, can it be the sole consideration for identifying and putting a particular class in the other backward class category. So for that, we have the Mandal Commission judgment. This is an important PT pointer for you. You may make a note of it. Indira Sawhney versus Union of India. I believe this was a 1992 or 1993 judgment. So this is called the Mandal Commission, Mandal judgment. So as with most cases where reservations have been challenged, the High Court relied heavily on the Supreme Court's verdict in the case of Indira Sawhney. A 9-judge bench had held in 1992 that OBCs cannot be identified and given reservation only on the basis of religion. The Supreme Court also held that all states must establish a backward classes commission to identify and recommend classes of citizens for inclusion and exclusion in the state OBC list. At present, in the present case, both the commission and the government submitted that the commission had identified 77 classes based on applications which were made by the citizens, and thereafter the recommendations were made for their inclusion to the government. Now, the High Court noted that the commission's recommendation had been made with lightning speed after the then Chief Minister publicly made an announcement that Muslims would be given reservations. So the court was of the opinion, court opined that, there was some other factors which were at play. So the court was essentially, signaling to the fact that right after Mamata Banerjee government made, public announcement that Muslims were given reservations, and this happened in February of 2010, the commission at a very, in a very speedy manner made recommendation to the state government, and so Muslim community should be included in the OBC category. So the court said that this was not based on any objective criteria to determine the backwardness of these classes, because usually there has been a debate in our constitution, and if you have a look at the case laws also, Article 15(4) and other articles with respect to that, wherein it has been categorically stated as to what can be the factors for considering a class as backward. Should there be social, educational, economic backwardness? Can a single ground, can caste be the sole classification ground for putting a particular class as OBC or backward class? So similarly here the court said that religion was the sole criteria which the government used to classify Muslim as the OBCs, and this was not based on any objective consideration. It was not based on any material on record. So in this respect, the court noted that religion indeed appears to have been the sole criteria for declaring these communities as OBCs, and the reports that the commission submitted were meant only to curtain and hide such religion-specific recommendations. This court's mind is not free from doubt that the said community has been treated as a commodity for political ends, and that 77 classes identified were being treated as vote bank. So this was the court's observation. Now let's understand the concept with respect to sub-classification and what the court has to say with respect to this case. Now please understand, this is often asked in your PT examination, so you may make a note of it. See, there is a case by the name of M.R. Balaji. In that case, the Supreme Court noted that classification of the backward classes into more backward or less backward, this is not permissible. But in the case of Indira Sawhney, the Mandal Commission judgment, it was allowed. So this sub-classification was permitted. The court also struck down in the present case the portions of the 2012 Act, including provision that allowed the state government to sub-classify OBC category into Class A and Class B, that is to say more backward and backward classes. And it also struck down provision allowing the state to amend the schedule of this Act to add to the list of OBCs. The commission, very interestingly, conceded before the court that the government did not consult it before creating the sub-classification within OBC reservation, but the commission at the same time argued that such an action was outside its purview. The court held that the state government must consult the commission to make a fair and impartial classification, including sub-classification. Sub-classification, so this is the purpose of sub-classification, which was reflected upon by the court. The court said that sub-classification is meant to address the different levels of deprivation which is faced by different communities, which the court held could only be done by referring to materials which is collected by the commission. So with this, we come to an end of our TNA. Thank you so much for watching. Have a wonderful weekend ahead.